You just got some bad news. Your landlord is keeping your security deposit. Maybe they're blaming damage that was already there when you moved in. Maybe they sent you a list of charges that just don't add up. Maybe they just went silent. Here's what most tenants don't know. Your landlord had a legal deadline to return that money. And in most states, if they missed it, even by one single day, they may have already lost the right to keep any of it. And they don't even know it. I'm going to show you exactly how to get it back. I'm a lawyer and I've handled more security deposit disputes than I can count. I've seen landlords send itemized lists full of made-up charges. I've seen tenants get back 3 times their deposit because the landlord didn't follow the rules. And I've seen people walk away from money that was legally theirs because they just didn't know they had options. But you do have options. Let me show you exactly what they are. So most tenants don't know this, and most landlords are going to count on you not knowing this, but your landlord does have a legal deadline to return your deposit. It's not open-ended, it's not whenever they feel like it. There is actually a specific number of days set by your state's law, and if that landlord misses it, the consequences are serious. In most states, that deadline is 21 to 30 days after you move out. New York gives landlords 14 days. California gives 21 days. Texas gives 30 days. Some states go all the way up to 45 days. Here's the part landlords hate. In many states, if they miss that deadline, they automatically lose that right to make any deductions. None. Zero. Zilch. They owe you the full deposit back. And in some states, California, Massachusetts, Maryland, and other states, a landlord who misses that deadline, well, they can be liable for 2 or 3 times the deposit amount. Not just what they kept, double or triple it. So the first thing you need to do right now is count the days. When did you move out? Has the deadline passed? Because if it has, your landlord may have already made your case for you. And they didn't even know it. Coming up next, here's a more thorough visual list of some states' security deposit deadlines, as well as the penalty if that deadline is missed. You know how at a magic show a magician might say, "A magician never reveals the secrets to their tricks"? Well, that's not what we're doing here. Let me tell you about the most common trick in the security deposit playbook. A tenant moves out. The landlord then sends a deduction list. And it looks normal, right? On that list, repainting the walls, replacing the carpet, cleaning fees. It looks official, it looks legitimate, yada yada yada. Most tenants are just going to pay it. But here's what those landlords don't tell you. Normal wear and tear is not something they can charge you for, ever, in any state. And that's their secret. They don't want you to know it. Normal wear and tear means the natural, gradual deterioration that happens from normal use of a property over time. Things like scuff marks on walls or minor carpet wear, small nail holes from hanging pictures. That's expected. It's part of renting and it's part of living. What they can charge you for, though, is actual damage. And by that, I mean things like a large hole in the wall, stains that won't come out, broken fixtures, things that go beyond normal use. The line between wear and tear and actual damage, that's where most deposit disputes are won or lost. And landlords routinely try to charge for wear and tear because they know most tenants won't challenge it. You should challenge it. That's their secret, and they don't want you to know it. Well, now you ask yourself the question, how do I build my case? Whether you're already in a dispute or you're just seeing the warning signs, here's how you do it. Listen up. Photos are everything. I'll repeat that. Photos are everything. Move-in photos, move-out photos, time-stamped and saved in 2 places. If you don't have move-in photos, get your move-in inspection checklist. That document, if you both signed it, that's the baseline for what the apartment looked like when you got there. If your landlord charges you for something, then they have to prove it. They need receipts. They need invoices. They need documentation showing the damage and what it costs to fix. In most states, a landlord who can't produce that documentation, well, they are out of luck and they cannot legally keep that deduction. Request the documentation in writing. Send an email or a letter asking for itemized receipts for every deduction. What that does is it creates a paper trail. And that paper trail, that puts your landlord on notice that you're not just going to lay down and accept their list willingly. Here's something I've seen work over and over and over again. When tenants send that letter, landlords suddenly find money that they forgot to return because they know they're dealing with a smart tenant and they know their deductions, they are not going to hold up when somebody actually looks at them. It's almost like they get a little scared when they see that list and they say, all right, I better play ball. Because if I don't, I'm in trouble. Now I know if you're here watching this video, that probably means you're trying to be in a rush to do something. You want to go to court, you want to get your landlord in trouble. But before you file anything in court, send a letter, a formal written demand to your landlord. What this letter accomplishes are three things. Number one, it states clearly that you dispute the deductions. Number two, it cites the specific law your state uses for security deposits. And number three, it gives your landlord a deadline, typically 10 to 14 days, to either return your money or explain their position in writing. Send it through certified mail and keep the receipt. This creates a legal record that you attempted to resolve it before going to court. That matters. Courts look favorably upon trying to reach an amicable resolution before filing the lawsuit. Most landlords, when they get this letter, they realize you're a smart cookie and you know what you're doing, and a large number of them at that point will pay up because they know that if this goes to small claims court and they lose, they might owe you double or triple what you're asking for now. I've linked a free letter template in the description. It's already formatted with the right language. You just fill in your name, your landlord's name, the amount, and the date. That's it. Now you're asking, well, if that letter doesn't work, what do I do? At that point, small claims court is your next move. I know that sounds intimidating, but it's not. Small claims court is specifically designed for situations like this. You don't even need a lawyer. You file a form, you pay a small fee, usually somewhere from $30 to $75, and you just show up. You might be asking, what do I bring with me? All you bring is your lease, your move-in inspection, your move-in photos, your move-out photos, a copy of your demand letter, and the certified mail receipt showing the landlord got it. That's your case. That's it. What is the judge going to look at with all of this? The judge is going to look at, did the landlord return the deposit on time? Are the deductions documented? Is there evidence of actual damage versus normal wear and tear? In many states, if you win, the landlord's going to pay your filing fee too. And if the court finds that the landlord acted in bad faith, meaning the landlord knew the deductions weren't valid, then you can be awarded up to 3 times the deposit amount. Good luck for you, bad luck for your landlord. I've seen tenants walk out of small claims court with $3,000, all from a $1,000 deposit. The law is on your side when landlords don't follow it. The landlords just don't want you to know that. You've heard a lot of information in this video, so here it is again, 5 steps, do them in this order. Step 1, count the days. Look up your state's security deposit return deadline and figure out if your landlord has already missed it. That answer changes everything. Step 2, pull your move-in inspection checklist and any photos you took. These are your baseline. If you don't have them, that's okay. Your landlord's deduction list still has to be documented. Step 3, request itemized receipts for every deduction in writing. Email your landlord today. Just 1 sentence. Please provide receipts and invoices for all deductions from my security deposit. Keep that email. Step 4, send the formal demand letter. I have a free template in the description. Fill it in, send it certified mail, keep the receipt. And finally, step 5, if the landlord doesn't respond or they refuse, file in small claims court. Use your state's court website to find the form. It takes less than an hour to file. One last thing before you go. If you're in a security deposit dispute right now, drop it in the comments. Tell me what they're trying to charge you for. I'll read every comment, and those real situations are going to help what I cover next. If this helped, subscribe to the channel. New video every Tuesday. And if your situation involves a landlord who entered your apartment without notice, not just the deposit, but actual entry into your space, I covered exactly what the law says about that and what you can do. That video is linked above. It's worth watching, just in case you've been there or find yourself there in the future. See you on Tuesday.